we're here today on a motion for summary disposition. I did get a request from Mr. Jones to adjourn this matter because of his eye concerns. Did you guys receive that as well? Ms. Antonia, how you pronounce your name?
Antino, Your Honor. Mr. Jones contacted us yesterday about this matter, and it was our understanding that at this point yesterday we were going to proceed with the motion hearing. We did discuss that it was possible we would not be ready for the final settlement conference that was also scheduled for today because we haven't received an answer to our discovery request at this point yet. And so we were understanding that we would proceed with our motion, but perhaps agree to move out the final settlement at this point.
I did receive additional documentation from Mr. Jones today. Did both counsel receive that?
Yes, we received some additional documents from Mr. Jones today. We haven't had a chance to review them. We got them at about noon today, but we were able to recognize that it was not fully responsive to our request. He sent us primarily just some photographs, and that was pretty much only responsive to one of the items that we requested.
Thank you. And Mr. Jones, do you understand the nature of the reason why you're here is twofold today? One is that they have filed a motion for summary disposition. Basically, they're arguing that you are not entitled to move forward on your case at all because they're entitled to a judgment as you did not follow the proper laws according to the Landlord-Tenant laws. And the Landlord-Tenant Act, it says that you're supposed to provide Mr. Diamond Evans with an itemized list of any damages within 30 days from his move-out date if he provides you with a forwarding address. And I haven't received a response to that. And then in addition to that, they're saying that you are unable to bring an action at this time because you missed the 45-day window that you're supposed to file the action within. Do you understand all those things, sir?
Yes, I don't agree with that, but
You did send him notice?
well, I sent it to his caseworker, which I believe he received through email.
You sent him the itemized list of damages to his caseworker?
Yes, we were going back and forth because Section 8 Ann Arbor Housing they have a program where they were going to cover a portion of the damages.
When are you planning to set that?
I'm sorry, you said when did I send it?
Yes, sir.
Oh, I'm sorry. I believe it was in April. I think I sent Libby.
Talking about this year?
No, last year. He was actually living in the property.
How he moved out in July? You can't send it to him before he moves.
That's what I'm saying, Your Honor. He was well aware of the damages before
It doesn't matter whether he's well aware. You have to follow the law, sir.
Okay. Well, my argument to that is that on the forwarding address, his C looked like a G, and also it's a multi-unit building, and he failed to put the building number on the forwarding address.
Okay. Do you guys want to talk about the settlement before I do the motion?
Your Honor, we requested these communications that he's alleging occurred with our client's caseworker in our discovery. And, we informed him that our client provided a valid address, and he has given us no indication that he attempted even to contact our client at the address that was provided. And so at this time, we believe that he cannot rely on assertions that he attempted to use this address and found it invalid when we've tried to communicate with him about the issue and have received no response to those communications.
So let's start with the initial thing. Mr. Jones, you're prepared to move forward on your motion for summary disposition today?
No, I'm not prepared.
Why not?
I'm sorry. I couldn't
I
hear you.
said why? I said why not?
Oh, I filed a motion, for more time, based on, well, the first motion was for, I had a couple funerals I had to attend to, and the second motion was, I'm having, health issues with my eyes. So I can't even really see good up front, tell you the truth, up close.
Have you all had any discussions at all regarding settlement on this case?
We talked a little bit, kind of vague. Miss Libby, she really couldn't give me I really asked her, like, what is she really looking for? You know, she really couldn't tell me. So,
They're asking for double his security deposit because you didn't follow the security deposit law.
yeah, I understand that part, but there's was it the inability, inhability? I can't even pronounce it. The inhabitable, how you say it?
The law says that if you do
Uh-huh.
not return someone's security deposit within the time frame that you're supposed to, then you owe them double. And they're saying that you violated the Security Act,
Mhm.
Security Deposit Act, and therefore you owe them double.
Okay, well, I reached out to his caseworker. I sent them the information.
How this works. You should know that when you go into settlement negotiations, which I'm putting you both in right now, whether Mr. Santa Croce is saying yes or no, I saw his face, but you guys gonna go and talk about this. I'm gonna give you one opportunity, Mr. Jones, to try to see if you can resolve this matter. If you don't, I'm gonna come back and make a ruling on their motion. You should heed what I'm saying right now. Okay?
Okay, so the motion that I requested, that's being denied.
You want me to make a ruling on that right now? I will. Or
Um,
do you want to talk like I just told you to?
Really don't know, tell you the truth.
Or
I
you're gonna
mean,
have to make a decision.
okay. So if you make a ruling, then we don't have to discuss this, right?
Oh, no, you won't have to discuss it.
Okay, all right. Okay, well, we can, I guess we can work it out, try to work it out. I don't know, I mean, what all they really want. I know they want double the required security deposit, but that's all she told me.
Talk and see if we can come up with anything. Okay?
Mhm. So as
Right.
far as my counterclaim, that's being denied as well?
Did you just hear what I said, Mr. Jones? If you want me to make a ruling, I can.
Okay,
I'm not gonna keep going back and forth with you.
okay,
Said you were gonna go make a ruling and now you're back to the same things. We're not doing that.
okay. I'm not trying to go back and forth with you, Miss Washington.
All right, let's go into the room and have a discussion.
Okay.
All right? Do you want your client present as well, Miss Antonin?
Yes, Your Honor.
Okay, thank you.
So at this point, we made an offer to Mr. Jones, and he provided us no counter offer. So at this time, we would like to proceed on our motion and go from there.
Mr. Jones, is that correct?
Yes, that's correct.
First thing I have to deal with is his request to adjourn today's motion due to his cataract issue. What is your position on that?
A position on allowing him more time before we hear the motion, Your Honor?
Correct.
Um, it's our understanding that, the Mr. Jones was aware of this for over a month now, and we had already adjourned one final settlement conference due to various other issues he's been having. And, we were in contact with him last week multiple times, as well as earlier this week, and he did not raise the issue. He did mention that he was going to visit a doctor, but, at that time, he never told us that this would change his ability to be prepared for the hearing on this motion. And so we would really think that it is in our client's interest to dispose of this motion now and, permit more time on discovery for the remaining damages issues if that is something that the court would be interested in.
Thank you. Appreciate it. Mr. Jones, do you want to make a better record of your request for an adjournment?
Yeah, I wish I could have a little bit more time to work on this case. I have a lot more respect for attorneys and judges now because it's a lot of work to do, on top of like working full time and trying to take care of yourself. So, um, I don't take nothing. I take my hat off to you guys for what you do. But I think if I had a little bit more time, I could probably prepare a little bit better for the case because, I think this was caused by my tenant, and I have to pay for it. But if that's the case, I just have to pay for it.
All right, Mr. Jones, I think that the part that you're missing is that what we're solely here for today is either a settlement or their argument regarding the Security Deposit Act. Did you review their motion around the Security Deposit Act?
Yes, it was, you got to respond in a certain amount of time, but I don't think he gave me a valid address, to tell you the truth, anyway. But, he left out the building number. Cargo looked like Gargo, you know.
So let me make a regarding the request. And this is what I'm gonna do. He apparently is very familiar with the actual motion and arguments behind it. And I will allow him to respond verbally since he has a problem with the reading portion of it so that he can actually provide us with a response. But I don't believe that I need to adjourn it for those purposes, and we can address that particular issue today. And we will move forward with respect to the Security Deposit Act issue. Having said that, just Antonello, you can make your motions on the record so that we can have a record of this in case anything gets killed.
Thank you, Your Honor. So we are here today to discuss our motion for summary disposition under MCR 2.116C10. The grounds for this motion are that other than damages, there is no genuine issue as to any material fact, that the defendant failed to provide an itemized list of the damages within 30 days of our client moving out of the property, and then failed again to file a claim within 45 days of our client moving out of the property. Mr. Jones first gave an itemized list of the damages 197 days after our client moved out of the property on July 3rd, 2025. He did this when he filed the claim in January of 2026. He attached the list, an itemized list of the damages. And this is just clearly much later than the anticipated dates by the statute. The statute itself provides a double damages penalty for retention of a security deposit when these deadlines are missed. Mr. Jones still retains the deposit today, and so we believe that he should be found liable for twice the deposit, which would be $2,400.
Right, thank you. And what statute are you referring to?
The Michigan Security Deposit Act sections 554.1 555.609 and 554.613.
Thank you. Which requires that he do what?
609 requires that he provide an itemized list within 30 days of the tenant leaving the property. And then the 0.6113 requires that he file his claim within 45 days or return the deposit, neither of which he did.
When you say file his claim, what do you mean?
File a claim to which he can seek to retain the deposit for the amount of damages that he alleges were at the property.
File where?
What was that?
File where?
Oh, file a claim with this court.
So he has to file an action in court in order to retain the security deposit, correct?
Correct, Your Honor.
Thank you. You did hear him say that the notice, so the notice provision requires that your client provide a proper address, a forwarding address, correct?
Correct, Your Honor.
And you did hear his argument that the address provided was not a proper forwarding address. Where do I find the address that he claims that was provided, and how did he provide that?
Yes, Your Honor. So you can find the address at exhibits C and D. Our client provided his address in writing on the day that he completed a final walkthrough on July 3rd on a paper that was specified as like a closing document for the two parties. And then he also provided the address as a text message on the same day, July 3rd, 2025. These are exhibits C and D.
So in the text message, it says 8521 Cargo Drive,
Yes, Your Honor.
Ypsilanti, Michigan.
That's correct.
Is there a apartment number?
It's our understanding that there is not an apartment number, and that our client had never used an apartment number with that address before. It's the address that he has on his driver's license, and he had no issues in the past receiving mail to that address exactly as written.
All right, Mr. Jones. Your response.
Okay, actually, I drove by the 8251 Cargo, and I looked at the building, and there is actually a building number on the property.
Maybe you went to the wrong address, because the address is 8521.
Yes, 8521, because it's located in front of Schooner Cove Apartments. And it's owned by McKinley, I believe. I think I was at the right building. So,
Did you attempt to send anything to that address, sir?
well, it's possibly it got lost in the mail, Your Honor.
You're not answering my question. Did you attempt to send anything to that address?
To the address?
Please raise your right hand, please, one. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You're on the oath. Did you attempt to send, you can lower your hand. Did you attempt to send an itemized list of damages to that address, sir?
No, I did. But I did send a list of damages to his caseworker, and he was notified by his caseworker about some damages.
And you told me earlier you sent that back in July. In April. You sent that in April. He didn't move until July.
Yep, I sent multiple text messages to her. Multiple text messages, and I got the runaround. That's why I reached out to Diamond, because stuff just kept popping up as I started working on the property. Like I noticed things like the refrigerator was damaged. There was cracks in the refrigerator. The stove was not safe. I don't know why the inspector missed that. She caught the floor, but she didn't miss. She missed the what is it called? The fire hazard on the stove. It could have caused a grease fire. And what else? Uh, Also, too, Diamond and his girlfriend, I believe they work from home, and so based off OSHA, they say that the flooring, as long as there's not a difference of a quarter of an inch in the flooring, it's not considered to be a trip hazard. And online now, they're saying that subfloors, you can use the subfloor basically as a finished floor. So in my eyes, the floor was okay. It was dried out. I did the remediation. They dried it out. There was no mold, um, just food particles on it, you know, and glue from tile that they had ripped up.
Anything further you want to add regarding your defense to the motion, sir?
I just want to add that Diamond, he broke the lease by doing modifications to the property without getting it in writing from me. And you know, he did that on his own. He caused the problem on his own. He hooked up the water line. He called me one day. He said, Nick, my uncle do work. He could hook up this water line. And I thought about it for a second. Well, I said, as long as we don't have no leaks, D. So I didn't say he could do it, and I didn't say he couldn't do it. I gave him a clause. So well, down the line we had some leaks. So I don't feel like I should be held accountable for that because he caused that. He didn't pull a permit. He didn't use a licensed plumber. And that's why we're here today.
Well, actually, that's not why we're here today. Why we're here today is because you didn't abide by the law that said you have to give him an itemized list of damages. If you did that within the 30 days, we'd be in a very different position. Or you have to sue him to retain his security deposit. If the law is set up in such a way that you have to follow that, or there are severe repercussions. If you're going to be a landlord, you've got to know the landlord-tenant law. You're held responsible for abiding by that. So I in no way, shape, or form agree with somebody's property being damaged or torn up or anything like that. Used to be a landlord myself. But you gotta follow the law, and that's the problem here. That you didn't do that. And so now we're here.
Yeah,
And
we
I've been
did.
trying to give you an opportunity to try to get this resolved without getting to this point. We didn't do that. So now I'm going to make my ruling.
Okay,
You
we
didn't
did.
follow the law.
We did
And
have an
therefore-
oral agreement that we wouldn't even go to court.
I'm sorry.
Me and Diamond did have an oral agreement that we wouldn't even go to court.
That's
You
the
know,
oral
but
agreement's not gonna work in this situation, Mr.
I
Johnson.
understand.
The motion for summary disposition is granted as to both points. One, he did not submit the itemized list to the forwarding address, which seems to be a correct forwarding address to me. He also did not file the actual claim, the case with the court to make a claim as to the security deposit in a timely fashion, and that is granted. I will sign an order to that effect. I believe it is here already. Do we want to continue to talk settlement?
Yes, Your Honor. We would request an additional 3 weeks and an order setting a specific date that Mr. Jones should complete our discovery by before we can get into a more fruitful final settlement on the rest of the damages issues.
I don't
So-
sense, Your Honor, anything's happening we're gonna get any further than we did 20 minutes ago.
And what are the outstanding damages issues beyond what we're dealing with today, in your opinion?
We would like to request an abatement of the rent for the year period where the kitchen was in complete disrepair for the flooring being ripped out, as well as the refrigerator being non-functional and the garbage disposal issue. We have requested documentation related to these matters from Mr. Jones in discovery and have received a few photographs, but no additional documentation on the issues as I've laid them out.
Well, it sounds like we might have a issue of fact with respect to that, because Mr. Jones is claiming that your client was the one who did the repairs.
That's correct. We believe that there is some issues of fact on the actual abatement of the damages to the premises, but that irrespective of that issue, the Security Deposit Act is not affected by who caused the damages.
I understand that.
Your Honor, I suspect what we have is an hour-long bench trial in our future, unless we can resolve this second piece with him, and we're prepared to do that. With the rest of discovery, perhaps we can have some more fruitful discussion to resolve the second half of the claim. There's I think a significant abatement claim, and he's got some defenses, and I hope we work it out. But we can't come to the table because we don't. He's claiming things that there should be documentation for, and we're just not getting it.
What do you mean, like the fact that your client was the one who did the work at the house?
Well, there was a leak on one side. There was a flood damage and a leak on one side of the kitchen, opposite from the water line that we don't believe leaked, that he was given permission to install and apparently installed it correctly. We think it's being misattributed. The pictures kind of, but again, these are just issues of fact that we're going to have to deal with. There's a real dispute, and I suspect that we can come to a compromise on the second half. We just want to talk to him intelligently about it. And then I'm losing all my troops. And we don't have possession as an issue. So we're just trying, would like to get the discovery, see if we can resolve it with him. If not, I suspect it's going to be an hour bench trial with 2 witnesses.
Right, I'm still trying to grasp a couple of allegations. One, there was the refrigerator repair, right? And you were claiming that there was an additional leak that wasn't the refrigerator repair?
In fact, the only leak wasn't the refrigerator.
The only leak was not the refrigerator. So your argument is that it wasn't the refrigerator that created this issue. I see. All right,
Other sides of the room.
I understand.
Yeah, but the floor in the kitchen is sloped, so it makes sense that the water is gonna go to the lowest point.
All right, then, when do you lose your student attorneys?
Like tomorrow? No,
It's not an issue.
it's soon, and it's always a shock. But if it's we have to get the discovery in, process it, and then we can and if you want to schedule us, do a final settlement conference at the time where we can have an hour-long hearing. If we can't resolve it, that might be all the better. I suspect we'll be able to resolve it. I hope to.
I'm not doing that. But I will schedule it. I'll schedule it for a final settlement conference again. Does June 4th work?
Let me triple check here. Thursday the 4th. Yes.
What outstanding discovery do you need?
Libby or Katie?
I'm not 100% certain, Your Honor. We did receive a lot of documents from Mr. Jones today, primarily just photographs. We were also requesting information related to the insurance on the property and claims made against that insurance. We were also requesting the communications between Mr. Jones and the caseworker. We were also requesting any communications with third parties, including people who have may have made repairs or came to remediate the issues.
That would be Diamond, wouldn't it? I mean, his uncle.
Correct, but we also wanted any communications or documents related to who you had come in to rip up the flooring and assess the issue when the major flood event occurred.
Okay, so when you say a flood, that's like gushing water.
Correct. It was our understanding that there was water dripping into the garage below.
Yes. So a little drip underneath from the garbage disposal wouldn't cause that type of damage, would it? That's a question. I'm just asking.
If there are additional documentation or people who worked on the premises afterwards, sir, you need to provide that documentation to them so that they can do any discovery that they may have. When we first started this case, I did limit discovery to, I believe it was 10 questions. And you're just indicating that of those 10 questions, this information is still outstanding, correct?
Correct.
So please try to give that to them, sir. You should get it to their offices. We're going back here on June 4th. You should have it to them within the next month. So let's say May 14th.
May 14th. Okay.
Right. We're on set here. I'm sorry?
You didn't actually.
Oh, I did give them a time.
Correct.
So let's do this at 2:30 p.m., please. I think I wrote it down, but I didn't say it out loud. I did write it down. Thank you. So we're gonna be back here on June the 4th at 2:30. All right, well, some of us will. Good luck to the rest of you. Thank you.
Thanks,
All
Your
right,
Honor.
thank you, Ms. Washington.
I
Have
might
a
not
good
let
day.
him go, Your Honor.
I can understand why. All right, thank you.
Be
Bye-bye.
well.
You too.